Salic law, or Salian law, was the ancient Salian Frankish civil law code compiled around 500 AD by the first Frankish king, Clovis. Recorded in Latin and in what may have been the oldest known official usage of Old Dutch, it would remain the basis of Frankish law throughout the early medieval period, influencing future European legal systems. The best-known tenet of the Old Law is the principle of exclusion of women from inheritance of thrones, fiefs and other property. The Salic laws were arbitrated by a committee appointed and empowered by the king of the Franks. Dozens of manuscripts dating from the 6th to 8th centuries and 3 emendations as late as the 9th century have survived. Salic law provided written codification of both civil law, such as the statutes governing inheritance, and criminal law, such as the punishment for murder. It has had a formative influence on the tradition of statute law that has extended to modern times in Central Europe, especially in the German states, France, Belgium, the Netherlands, parts of Italy, Austria-Hungary, Romania, and the Balkans. History of the law. The original edition of the code was commissioned by the first king of all the Franks, Clovis I. Earlier than its publication date, sometime between 507 and 511. He appointed 4 commissioners to research uses of laws that, until the publication of the Salic law, were recorded only in the minds of designated elders, who would meet in council when their knowledge was required. Transmission was entirely oral. Salic law therefore reflects ancient usages and practices. In order to govern more effectively, it was desirable that monarchs and their administrations have a written code. The name of the code comes from the circumstance that Clovis was a Merovingian king ruling only the Salian Franks before his unification of Francia. The law must have applied to the Ripuarian Franks as well, however, containing only 65 titles, it may not have included any special Ripuarian laws. For the next 300 years the code was copied by hand and was amended as required to add newly enacted laws, revise laws that had been amended, and delete laws that had been repealed. More so than printing, hand copying is an individual act by an individual copyist with ideas and a style of his own. Each of the several dozen surviving manuscripts features a unique set of errors, corrections, content and organization. The laws are called titles, as each one has its own name, generally preceded by de, of. Concerning different sections of titles acquired individual names revealing something about their provenances. Some of these dozens of names have been adopted for specific reference, often given the same designation as the overall work, lex. Merovingian phase. The recension of Hendrik Hearn organizes all of the manuscripts into 5 families according to similarity in relative chronological sequence, judged by content and datable material in the text. Family I is the oldest, containing 4 manuscripts dated to the 8th and 9th centuries but containing 65 titles believed to be copies of originals published in the 6th century. In addition, they feature the Malbergse Glossen, Malberg glosses, marginal glosses stating the native court word for some Latin words. These are named from native Malbergo, language of the court. Kern's family II, represented by 2 manuscripts, is the same as family I, except it contains interpolations or numerous additions which point to a later period. Carolingian phase. Family III is split into 2 divisions. The first, comprising 3 manuscripts, dated to the 8th–9th centuries, presents an expanded text of 99 or 100 titles. The Malberg glosses are retained. The second, 4 manuscripts, not only drops the glosses, but bears traces of attempts to make the language more concise. A statement gives the provenance. In the 13th year of the reign of our most glorious king of the Franks, Pippin, some of the internal documents were composed after the reign of Pepin the Short, but it is considered to be an emendation initiated by Pepin, and is therefore termed the Pippiner Recensia. Family IV also has two divisions, the first comprising 33 manuscripts, the second, 1 manuscript. They are characterized by the internal assignment of Latin names to various sections of different provenance. Two of the sections are dated to 768 and 778, but the emendation is believed to be dated to 798, late in the reign of Charlemagne. This edition calls itself the Lex Salica Emendata, or the Lex Reformata, or the Lex Emendata, and is clearly the result of a law code reform by Charlemagne. By that time his Holy Roman Empire comprised most of Western Europe. He adds laws of choice taken from the earlier law codes of Germanics not originally part of Francia. These are numbered into the laws that were there, but they have their own quasi-sectional title. All the Franks of Francia were subject to the same law code, which retained the overall title of Lex Salica. These integrated sections borrowed from other Germanic codes are the Lex Ribuariorum, later Lex Ribuaria, laws adopted from the Ripuarian Franks, who, before Clovis, had been independent. The Lex Alemanorum took laws from the Alemanni, then subject to the Franks. Under the latter, they were governed by Frankish law, not their own. The inclusion of some of their law as part of the Salic law must have served as a palliative. Charlemagne goes back even earlier to the Lex Suaorum, the ancient code of the Suebi preceding the Alemanni. The language question. The Salic law code contains the earliest surviving attestations of Old Dutch. They consist mainly of stray words or glosses, but include a full sentence. Old Dutch and early modern and earlier versions of English used the original second-person singular Germanic pronoun. That attested in early modern English as thou, thee, and retained in modern German as du, dich. Modern Dutch and modern English reflect the substitution of the third-person plural form for both the second-person singular and the second-personal plural forms, first in polite conversation and deferential address and later in all contexts. CTV distinction. Villain was a form of serf in the feudal system. The English word is derived from a Middle French term that evolved from a Latin root. Villains were half-free farmers, connected to the land of the lord for whom they worked but not owned by that lord. In contrast, a serf was fully owned by the lord. Some tenets of the law. These laws and their interpretations grant insight to Frankish society. The criminal laws establish damages to be paid and fines levied in recompense of injuries to persons and damage to goods, e.g., slaves, theft, and unprovoked insults. 1/3 of the fine paid court costs. Judicial interpretation was by a jury of peers. The civil law establishes that an individual person is legally unprotected if he or she does not belong to a family. The rights of family members were defined, for example, the equal division of land among all living male heirs in opposition to primogeniture. Agnatic succession. One tenet of the civil law is agnatic succession, the rule specifically and explicitly excluding females from the inheritance of a throne or fief. Indeed, Salic law has often been used simply as a synonym for agnatic succession. But the importance of Salic law extends beyond the rules of inheritance, as it is a direct ancestor of the systems of law in many parts of continental Europe today. Salic law regulates succession according to sex. Agnatic succession means succession to the throne or fief going to an agnate of the predecessor, for example, a brother, a son, or nearest male relative through the male line, including collateral agnate branches, for example very distant cousins. Chief forms are agnatic seniority and agnatic primogeniture. The latter, which has been the most usual, means succession going to the eldest son of the monarch. If the monarch had no sons, the throne would pass to the nearest male relative in the male line. Female inheritance. Concerning the inheritance of land, Salic law said, but of Salic land no portion of the inheritance shall come to a woman, but the whole inheritance of the land shall come to the male sex. Or, in other transcript, Concerning terra salica, no portion or inheritance is for a woman, but all the land belongs to members of the male sex who are brothers. As actually interpreted by the Salian Franks, the law simply prohibited women from inheriting, not all property, but ancestral, Salic land, and under Chilperic I sometime around the year 570. The law was actually amended to permit inheritance of land by a daughter if a man had no surviving sons. The wording of the law, as well as common usages in those days and centuries afterwards, seems to support an interpretation that inheritance is divided between brothers, and, if it is intended to govern succession, it can be interpreted to mandate agnatic seniority, not a direct primogeniture. In its use by continental hereditary monarchies since the 15th century, aiming at agnatic succession, the Salic law is regarded as excluding all females from the succession as well as prohibiting succession rights to transfer through any woman. At least two systems of hereditary succession are direct and full applications of the Salic law: agnatic seniority and agnatic primogeniture. The so-called semi-Salic version of succession order stipulates that firstly all male descendants is applied, including all collateral male lines, but if all male agnates become extinct, then the closest female agnate of the last male holder of the property inherits, and after her, her own male heirs according to the Salic order. In other words, the female closest to the last incumbent is regarded as a male for the purposes of inheritance, succession. This is a pragmatic way of putting order. The female is the closest, thus continuing the most recent incumbent's blood, and not involving any relatives who are more distant from him than necessary. Using this order, the original primogeniture is not followed with regard to the requisite female. She could be a child of a relatively junior branch of the whole dynasty, but still inherits thanks to the longevity of her own branch. If male preference primogeniture were to be applied instead, the daughter of the last male incumbent would inherit only after the extinction of all other senior female lines. If no senior female lines exist, then the semi-Salic law and male preference agnatic primogeniture would yield the same woman as heir. From the Middle Ages, we have one practical system of succession in cognatic male primogeniture, which actually fulfills apparent stipulations of original Salic law. Succession is allowed also through female lines, but excludes the females themselves in favor of their sons. For example, a grandfather, without sons, is succeeded by his grandson, a son of his daughter, when the daughter in question is still alive, or an uncle, without his own children, is succeeded by his nephew, a son of his sister, when the sister in question is still alive. Strictly seen, this fulfills the Salic condition of no land comes to a woman, but the land comes to the male sex. This can be called a quasi-Salic system of succession, and it should be classified as primogenital, cognatic, and male.